Welcome to the DC Bar Community's Law Student Podcast with your hosts,
Sienna Hurd, 2L at American University, Washington College of Law.
Kirsten Wolford, 3L at the George Washington University Law School.
Renata Mitchell, 3L at the George Washington University Law School.
Elena Hoffman, 2L at the George Washington University Law School.
And you're listening to Let's Brief It. Hello and welcome to Let's Brief It. We're your hosts, Sienna Hurd and Kirsten Wolford. Today we're jumping into the realm of international arbitration. We're joined by Gaela Gehring Flores, a practitioner in international arbitration and co-host of the podcast, The Tea on International Arbitration.
Thank you so much for being here today. Before we get into the details of international arbitration, would you mind telling us about yourself, what your path looked like from law school to where you are today?
Sure, of course. Thank you for having me here. It is a great honor and pleasure to be here speaking with you, especially given our virtual environment right now. It's great to be able to connect with people across cyberspace. So my practice, and how did I get here? Specifically, my principal practice is international investment arbitration, and we can get into that a little bit later. I also do international commercial arbitration, but there is a pretty big distinction that might not be particularly intuitive to law students. It might not be that relevant to your studies. But my principal practice is international investment arbitration. And I've been doing that for the most part. It's taken up the bulk of my practice since like 2002. I was in law school in the early 90s. And that was essentially the era in which the practice that I am now in was being formed. That was just kind of like the primordial soup, as it were, for international investment arbitration, because that's when many of the international investment treaties were being signed. Before the early 90s, there really weren't that many investment treaties. But starting in the 90s, there was just a huge push all around the world for countries to enter into these investment treaties. And now we have well over 3,000 of these international investment treaties. Disputes in this area didn't really kick up until maybe the year 2000, about the early 2000s. So when I was in law school, my field of law it really wasn't on the radar screen at all. There certainly weren't any classes on it. Never, ever studied an investment arbitration award or case, nothing. I think at most or at best, we studied very briefly some international commercial arbitration cases, and that was about it. So I didn't really have a concept of doing this in law school because it just didn't really exist. And at the time when I was in law school, I am bilingual in English and Spanish, and a lot of professors would kind of steer me toward more transactional or corporate work, because that's where a lot of people with language skills would go at the time. I, however, in law school was pretty sure that I was more interested in a more litigation type practice. And that was actually confirmed when I was a summer associate at a law firm that had a really strong litigation practice. And I did a little bit of corporate work and figured out that it wasn't my thing. Then when I graduated from law school, I clerked for an amazing judge on the DC District Court, Judge Paul Friedman. And I did that for 2 years. And that just cemented my interest and love for more of a litigation type practice, or even a trial practice, as opposed to transactional practice. After I clerked for a couple of years, I returned to the firm where I was a summer associate, and it happened to turn out that when I started back there as an associate, one of my first major matters was an international commercial arbitration. And one of the reasons why I picked that particular firm and why it really clicked with me is because it had a really strong litigation practice, but it also had a very strong international clientele. And I figured, well, I know I really like litigation, and I might not be able to use my language skills that much in US litigation, but at least I will get that part of me that really needs more of some sort of international flavor in my life. At least I'll get that fulfilled because a lot of the clients that I'll have will be foreign to the United States. And as it turns out, the international commercial arbitration practice really did satisfy that desire in me to practice in a more international way. And then once I was a senior associate at that law firm, the judge I clerked for actually called me up and asked me if I might be interested in interviewing at another law firm, where he had heard they were interested in creating a practice that was focused on Latin America. So they wanted someone who was bilingual in English and Spanish. And they also needed someone who was experienced in international arbitration. And he just kind of said, well, I know that you really like the law firm that you're at now, but this seems like a huge opportunity for you. I think he actually said, now what this practice does is somewhat of a mystery to me. It's called investment arbitration, but it sounds like you can actually draft briefs and give oral argument in other languages other than English. And he encouraged me to check it out. And I did. And so I ended up going over to that law firm. And from that point, that was in 2002, the majority of my practice started being international investment arbitration. And that's how I got to where I am. And eventually I helped build up the practice at that law firm. And then that practice eventually came to Arnold and Porter, where I am now, where we have a really dynamic international investment arbitration practice and an international commercial arbitration practice. So that's how I ended up where I ended up. I definitely did not think I was going to end up here, especially because the path to where I am didn't really exist when I was in law school, but that's how I got here.
Thank you so much, Gaela. You mentioned, not being super familiar originally with international arbitration, both commercial and investment. And I can definitely resonate with that. I know personally, I'm involved in the VIS International Commercial Arbitration moot, and signing up for it really for me was, my friend, asked me if I wanted to be on the team. I said, I have no idea what that is. So because I know we probably have listeners who are in a similar position of not quite knowing what international arbitration is, I thought I would give a brief overview. So international arbitration is a form of alternate dispute resolution through which parties in different countries can resolve disputes outside of the domestic judicial system. And through arbitration, the parties are able to come to an agreement on the type and number of arbitrators, the place of arbitration, applicable law, the calendar, and procedural rules. Arbitration is like a middle ground between the traditional judicial system, where the judgment is binding on both parties, and the mediation process, where the mediator's decision is more like a suggestion to the parties. Gaela, does that sound accurate to you?
Yes, I think with a couple of tweaks. I think you had said that through arbitration, parties are able to come to an agreement. I think it's a little bit the other way around. If the parties are able to come to an agreement, then arbitration becomes a thing. And I'll probably repeat this phrase over and over in this podcast, but it's a very common phrase to international arbitration, which is consent is the cornerstone. You don't have anything in international arbitration without consent. And then whether, arbitration might be seen as kind of a middle ground between, a traditional court system versus a mediation process where, traditionally court decisions are absolutely binding on the parties and a mediator's decision is more suggestive. I don't know if international arbitration is more of a middle ground in that sense, only because an international arbitration award isn't really a suggestion. because the parties consented to this international arbitration process, once they've consented, they're kind of, I don't know, for lack of a better metaphor, strapped in. That's it. So when when an arbitration tribunal issues its award, that's binding on the parties, unless the parties came to some really interesting agreement that the arbitrator's award would just be suggestive, which is usually not the case. So I think it's a middle ground in that it's more of a neutral forum, but people shouldn't mistake it as some sort of, optional thing, because once you get on the arbitration train and you're strapped in, once the award comes out, it is, and maybe contrary to what people used to think, it is quite enforceable. So those are my tweaks.
Thank you for those clarifications. I really appreciate it.
And thank you for the background on international arbitration too. Kind of jumping right into it, precedent obviously carries a different weight in international arbitration than it might in the domestic court setting. So how would you say that precedent functions differently in your area of arbitration?
So because international arbitration necessarily is crossing legal cultural borders, and I don't know if you've had the opportunity to take a comparative international law class, but the common law system certainly is not the be all end all in the entire world. We kind of have two different worlds. There's the common law system, which is generally followed by most of it generated in the United Kingdom, and it's generally followed in a lot of the former English colonies, including the United States and Canada. But the rest of the world is on a civil law system. And as a general matter, the civil law system doesn't have precedent. So in the international arbitration realm, it would be difficult to kind of impose a system of precedent or stare decisis in a world where that wouldn't make a lot of sense to the majority of legal practitioners. So yeah, there is really no precedent in international arbitration. There is persuasive authority, and I think that's probably in large part due to a huge influence of common law practitioners in international arbitration. So a lot of international arbitration briefs or pleadings, or whatever word you want to use, memorials, they tend to be called, you'll see they might look a lot like a brief you would file before a US court, because people are citing to other international arbitration awards as authority. In this case, it's always persuasive authority. It can't be precedent. And as a general matter, or as a practical matter, the awards that are issued by arbitrators who are known in the field as being extremely experienced, those awards tend to have a little bit more persuasive weight. And so that's precedent. And then again, to differentiate international commercial arbitration from international investment arbitration. So international commercial arbitrations are governed by the law of the country that the parties agree to in their arbitration agreement, in their contract. And a lot of those contracts, a lot of those arbitration agreements are usually designate New York as the law that governs their arbitration. I think a lot of people came to think of New York as this international legal center, and the New York court system as a rather sophisticated court system that could understand and has experience in international concepts. So you have international commercial arbitrations that are governed by New York law, maybe London, maybe Paris. International investment arbitrations are governed by public international law, which I'm sure a lot of US law students learn even today is not a thing. But it is a thing. These international treaties do exist. Countries have signed up and committed to certain obligations under international treaties. in the instance of investment treaties, countries like the United States, almost every country in the world has entered into one of these investment treaties, or maybe a trade treaty that has an investment chapter. And a lot of the original, like the OG investment treaties were signed in the maybe late 80s, early 90s. There's a new generation of treaties coming out where the countries are kind of tinkering with the language of the older treaties. And that's how public international law on investment arbitration evolves. So we don't really have precedent per se, we have persuasive authority, and then we can see the evolution of investment treaty law in the evolution of the treaties themselves.
And right now, for the first time, domestic courts are entering this new world of increased virtual interactions, although I imagine this might be a more common occurrence for those involved in international arbitration. Do you think that this area of law was able to handle the impacts of the pandemic more easily in terms of virtual processes?
Absolutely. And I think, again, a lot of that has to do with consent of the parties, and consent being the cornerstone of international arbitration. There are rules that parties can look to in commercial arbitration or investment arbitration, whether they be the ICC rules, LCIA. There are a variety of institutional rules that parties can refer to kind of govern the procedure in their international commercial arbitrations. There's also UNCITRAL rules and ICSID rules for international investment arbitrations. But again, because consent is the cornerstone, there's always this concept that if the parties agree, as long as they consent to perhaps some slightly different process, then that's okay. Because unlike, the U.S. rules of civil procedure, which are quite binding on the parties and extremely difficult to move and tinker with, in the international arbitration system, you have a set of rules that are very binding, but if you get the parties to agree on some other system, that's okay. And over the years, international arbitration has been inching toward certainly all electronic filings, like trying to reduce paper, trying to reduce all the printing that you have to do. The parties have really been evolving towards that over the past 10 years or so, to the point where, it was very common maybe 15 years ago to have to print out many, many copies, hard copies of your briefs and your witness statements and your expert reports and all the exhibits, which is a lot of paper. We used to have to file physical copies all the time, and that's just not really a thing anymore. We may have to file a few hard copies, but we don't really have to file, the multiple hard copies anymore. And a lot of the filings are just done via email or, via some sort of box system or whatever. We just drop it on some server. That's been happening. And I think the pandemic basically pushed international arbitration, gave it a little bit more of a nudge into the virtual sphere. And since the pandemic, I've had hearings via Zoom or via WebEx. It's something that came very naturally to the international community. I'm sure international clients very much appreciate the cost savings of not having to have to fly their lawyers all around the world to be involved in hearings. Or I know people think of the word hearing and they think of some sort of motions hearing, but hearings in this space are a little bit more like trials where you have to cross-examine witnesses. And we've done that. We've done that over Zoom and WebEx. We've figured out a way. It's a challenge. Physical hearings and trials are a challenge. And, it's very different in a virtual space. But yeah, international arbitration has absolutely jumped into that. And we'll see if we go back.
It sounds like from what you've said, there's a lot of flexibility involved. So for our law students that might be interested in a career in international arbitration, what other skills do you think are helpful?
I think advocacy skills above all. Again, I think a lot of people mistakenly think of international arbitration as some sort of animal extremely different than litigation. It's not, it's an alternate litigatory practice, essentially. So if this is something that you're interested in, or, the converse, if trial advocacy is something that you're interested in, then international arbitration is probably something that you would be very interested in. It actually is a stylized trial practice, and particularly in international investment arbitration, where very few of the cases settle and a high percentage of your cases go to trial or to hearing. You really can flex those trial advocacy skills. So yeah, I think trial advocacy, writing, analysis, all of those things that are important to a litigation practice. But also, I think the tweak to international arbitration is just being aware of the world in which you live and all of the different cultures that we're swimming in. Certainly, if you are a US trained lawyer and you walk into an international arbitration, with both US litigation guns blazing, it's probably not going to turn out very well for you. You have to be cognizant of your audience at all times, and your audience is not the United States, and it's not a US judge, and it's not a US jury. And you have to be extremely sensitive to the different legal cultures that are playing out in an international arbitration. You cannot be US focused or think that legal culture is some sort of monolith and think that it all comes from the United States and the US is the be all end all of legal culture, because it's not. So I think that's an extremely important component to an international arbitration practice.
From the outside, international arbitration often seems like a tight-knit group of very experienced practitioners. So how does one initially break into the field as an arbitrator? Do you have any tips for getting initially into the scene?
As an arbitration practitioner or an arbitrator?
We'll go with both, but we can start with practitioner.
Yeah. I guess it could be compared to, how do you practice trial law and then how do you become a judge, essentially, which is, the judge question or the arbitrator question is very carefully, with a lot of difficulty. The becoming an actual practitioner in international arbitration, as a general matter, you do things that open doors. Any law firm worth its salt has an international arbitration practice. It's out there, and I think given how a lot of countries or states in the world are becoming much more nationalistic, much more isolationist, much more xenophobic, parties might be turning more and more to international commercial arbitration instead of the courts soon. So, I don't see international commercial arbitration going away. So how do you get into this practice? Well, do things that create connections, that open doors for yourself. As a law student, that probably starts with excelling in law school. Most legal practices, whether we like it or not, have, certain formulas or expectations with respect to grades, being on journal, things like that. So essentially endeavoring to do the things that open as many doors for you as possible. So excelling at law school, be a research assistant for an awesome law professor, be on law journal, do moot court, do the vis moot, take a trial advocacy course, do a clerkship. And that doesn't mean just in US courts. You can do a clerkship on the Permanent Court of Arbitration. You could do a clerkship at the ICJ. You could be a clerk or an intern for any of the many international arbitration institutions that exist, like the ICC or the LCIA or the ICDR, which is the international component of the AAA arbitration institution in the United States. You can do all of those things. You can also hone your language skills and take interest and show your interest in understanding of international law, of the different legal cultures that exist in the world. I think that's how you get into the field.
Well, thank you so much for taking the time to be with us today, and thank you for sharing the tea on international arbitration. It's been fun getting to delve into this type of law with you.
Wonderful to speak with you. Thank you so much for having me.
The DC Bar law student community strives to engage and support law students before you graduate and expose you to the tangible benefits of joining the DC Bar and DC Bar communities. Curated programming allows law students to participate in substantive content programming, leadership trainings, networking with practicing attorneys in fields of interest, writing opportunities, and other activities designed to expand your legal education beyond the classroom. Make an investment in your legal career by joining the law student community. To learn more, visit us at www.dcbar.org or email communities@dcbar.org. We look forward to hearing from you.